show on TV.
Well, you was lucky then. Oh, all right, let's get started because I don't want to keep you all long because we're going to spend the next class actually going over the areas for the review. And so I wanted to start just by let's going over.
Miss Archer, I have a question before we move on. Please.
Okay, go ahead.
It has to do with the PTC. And you know how the PTC can have 5 or more trusts under it that are blood related?
Mm-hmm.
What happens if a trust has a group of beneficiaries who are descendants of the settler and their spouse? So the spouse is not blood related. How does that work?
I'm trying to remember. I can't remember if the beneficiaries are spouses in any of them that I can't recall. I remember all the family members operating it, but off the top of my head, I can't remember.
Because when they say blood, they mean like brother, sister, daughter.
All of
Yeah.
that, yeah. All of
Okay.
those,
Okay, all right.
yeah. I can't remember. I can't because the one that's coming, or the 3 or 4 or 5 that come to my head that I deal with often,
Mhm.
saying spouses.
You have not seen spouses?
No,
Okay.
I've not seen spouses. Have you
Okay.
seen it?
Well,
you don't-
the one that I know about, it includes spouses. And I never realized that when it meant blood relation, you know? It just always said family. It had to be a family. So
Mhm.
I questioned that to say, what does that really mean?
Let me see. I'm thinking now. Trying to see. I'm trying to think. How that would work. Because I don't recall. I mean, it may be there, you know.
Is it just that if the PTC has multiple trust structures, it has to be blood relatives? Because I know of one of the structures that I deal with, the PTC, one of the beneficiaries is a spouse and the children. But it's only that one trust structure.
It's not across the board for all.
No. So the client has a trust that they have a PTC as trustee of the trust, and then they have underlying companies. So that PTC only exists to be the trustee of that specific trust.
The trust that includes the spouse?
Yes, the spouse is one of the beneficiaries. Well, the settler is the primary beneficiary, and then at their death, the spouse is one of the beneficiaries, and the children.
The children that will be the grandchildren of the settler?
No, they're actual children.
Okay. Okay. Okay.
I guess it's all still family, I guess. Once you marry, you become an in-law, eh?
Right. But what threw me is I always knew the family thing, but what threw me is when it said blood.
Okay, so it's blood relative or related by some other family relationship.
Okay. All right, cool.
So that's the full category of some other
Mhm.
relationship.
Okay, all right, thank
Yeah.
you.
I was trying to get the wording. I found it.
All right,
So I
thank you.
guess the purpose of that then is so that PTC doesn't exist to, I guess, take the place of an actual trust company, because then you could have like I could form a PTC and just essentially take on trust business without actually being regulated. Does that make sense?
Yeah, I get what you're saying. Yeah,
Okay.
yeah. I get what you're saying. All right. So tonight is, let me see. And Deandra's not even on. Okay.
It's being recorded, Miss Archer.
Okay, then. So let me let y'all go to enjoy your holiday. Who read what's written on the modern developments? Dalia, you saw from 3 o'clock.
I did not.
Lord, Lord. Who did? Lavette, did you read? Melissa?
No, mom, I didn't. I just got home, actually.
Oh, she wasn't one of the early birds.
I
All right.
didn't.
No, okay. So the modern developments in trust law, we're not talking about things that just happened yesterday. Because you know how law works. New as anything in the last 20 years. So there have been some amendments to the Trustee Act. One of them is what we call a directed trust. So trustees are absolved from any liability when they act on instructions from the power holder. Now remember the case of Raman, where the court ruled that the settlor himself was still directing the trust, and the trustee was not exercising his powers. So what we did in the Bahamas is we amended the Trustee Act whereby the settlor can give the trustee instructions on how to invest. And as long as he follows those instructions from the settlor, then he's not liable if there is any loss. So they also did an amendment that allows for arbitration. So if there is a dispute, instead of going to court, which is very costly, they'll go to arbitration instead. And with arbitration versus the court, of course, you have privacy. And then you don't have to be worried about your personal information getting out all over the place. Or what the assets are that you are fighting over. So that's why you don't see a lot of trust cases in the public domain now. There are very few that you'd actually see that are publicized. Then the next amendment they gave is when a beneficiary challenges the validity of the trust, their interest as a beneficiary may be terminated. So that means that when the settlor drafts the trustee in today's time, he can put a provision within the trustee to say that if the trust is challenged, then that beneficiary's interest is terminated. The next amendment they did was the abolition of the perpetuity period. So the perpetuity period in the trust instrument can be increased up to 150 years. So the approach they took is that the trustee will always act in what is in the best interest of the trust. So this new act, the Rule Against Perpetuity's Abolition, abolishes the perpetuity period for Bahamian trusts, and it allows the settlers to plan, preserve, and manage their wealth for several generations. But this also means it for the settler, he can find ways in which to alleviate paying, not paying, but alleviate looking at tax implications. So this part here, but the abolition of perpetuities has made the Bahamas a very attractive destination for trusts. There are a lot of people who come to the Bahamas to establish trusts. They like the flexibility. They like the structuring, how it is done. And they also like having that, I guess, ease of dealing with Bahamian lawyers who have association with other lawyers around the world who can look at their tax implications. Then there is a provision that was put in 2016, which was the implied indemnity of trustees. And with that, what that did, it clarified an existing section in the Trustee Act. And it says that an outgoing trustee is restricted from claiming a relief in respect of liabilities for breach of trust. And that is if he would not have been entitled to that release, if he had remained a trustee, it means that he cannot get indemnification. Or to clarify that a release given by a continuing or new trustee is limited to the trust property in his possession or under his control from time to time. Or to allow the settlor and the donors of property to a trust to benefit from non-alienation provisions in the trust. So notice that all of these amendments are just ways in which the, I guess, the trust practitioners trying to close loopholes in the legislation, one. Two, making the legislation more attractive for persons who wish to establish trusts in the Bahamas. Then what they did was they codified the rule in Hastings-Bass. Now the rule in Hastings-Bass was always said in the negative. If you were to read that case, you'd be totally confused because how it is written, you wouldn't understand it. It means the opposite of what it is saying. So in the case of Metoy Pension versus Evans, that's where they tried to translate it into a positive. So what the judge was saying, that where a trustee acts under a discretion given to him by the terms of the trust, the court will interfere with his action if it is clear that he would not have acted as he did had he not failed to take into account considerations which he ought to have taken into account. And so here what the court looks at, if a beneficiary is challenging a trustee, the court looks at what were the considerations the trustee should have taken into account. And if he had taken it into account, then what would have been the result? Now, there's also an amendment done for the definition of what a fiduciary power is. And it is a power that, when exercised, must be exercised for the benefit of or taken into account the interests of at least one person who holds the power. And in the case of a purpose
Miss Archer dropped?
That's how it seems. Karen
Oh,
must
okay.
take
Okay, I wanted to make sure it wasn't me.
Too much partying.
Zacha, they say you shouldn't be in class tonight, eh?
Man, where Miss Archer reading from anyway?
All over in the last unit. I don't know if her page is ordered the same as ours.
Oh, because I was nice and lost.
Natasha, you back for real? Guess not.
All right, class.
I think it's a sign. I think it's a sign.
You're so wrong. You're wrong.
What happened?
Oh, you are here.
Yeah, I am here.
We saw your name on the screen, but we couldn't hear anything, so we didn't know if you were here for real, for real.
I was here for real, for real. I heard y'all talking about me, saying,
Wonderful.
okay.
Wonderful.
We
Anyhow.
just wanted to know if you was with us, if it was a sign
I-
that we could leave.
No, I want to make sure I get this in before I do it again. Now, so, we have the common law duty, right to information. We also have the statutory. Now, there was a case in 2017, URSEG and URSEG. And in that case, it confirmed the court's important role in supervising trustee decisions to not disclose information to beneficiaries. And in that case, the court clarified the supervisory role. They say this decision should assist beneficiaries in holding trustees to account. It stated that the court must exercise its own judgment whether disclosure ought to be made after a careful assessment of a wide range of considerations. In this case, it was clarified that the bankruptcy of a discretionary beneficiary does not affect his or her capacity to seek disclosure of trust information from the trustees or from the court. And this case, the summary of this case is online, URSEG versus URSEG. The next case is Dawson Damer versus Taylor Wessing LLP. And this was a subject access request that was made pursuant to the Data Protection Act. Taylor Wessing, who was acting for the trustees of several Bahamian trusts, had refused to provide the requested data on the following grounds. One, it said the information was privileged. Two, the effort that would be involved in dealing with the request would be disproportionate. Three, the motive behind the subject access request was to obtain information that could then be used in legal proceedings. And the Court of Appeal found that the legal professional privilege exemption under the Data Protection Act should be construed narrowly. Remember when we did, I think it was the first chapter, and we spoke about confidentiality, and included in confidentiality, we add to that the Data Protection Act. And one of the exemptions under the Data Protection Act is when you have legal professional privilege. So in this Bahamian case, the court ruled that that is not to be construed broadly. It is very narrow. And it doesn't extend to documents not disclosable to a beneficiary of a trust under trust principles. Second, the Court of Appeal said there was insufficient evidence to demonstrate that the search would be disproportionate. And third, the intention to use information obtained from a subject access request in legal proceedings was not a reason to avoid compliance with a request. And so they had to provide the information. So the comment was made that the decision is likely to give rise to beneficiaries seeking to use subject access requests to circumvent the established principles in Reed, Londonderry, and Schmidt concerning a beneficiary's right of access to trust documents and information. And of course, you know, under CRS, FCSPs are obliged to report information on offshore companies in relation to their ultimate beneficial owners. I don't need nobody falling asleep as yet. Be wide awake. So you can look up EarthSag and EarthSag. It's a New Zealand case, and there are excerpts online. Now I have another recent one that happened in May 2021, and this one is called In the Matter of the May Trust. This is a Jersey case, and what it shows is the modern world's acceptance that inherited wealth is increasingly intertwined with a family's purpose and values, tax morality, and public reputation. The case is interesting to generators and beneficiaries of private wealth, trustees and custodians of private wealth, and their advisors. It illustrates how the courts can take a more flexible approach to interpreting existing trust law, enabling fiduciaries to work together with families to fulfill the family's philanthropic objectives. So in this case, this concerned a trust. The value of the trust was approximately 150 million pounds. The trust was governed by the law of Jersey. The beneficiaries of the trust were the principal beneficiary, his family, and a family's charitable foundation. So the trustee went to the court to ask the court to consider a proposed distribution to the principal beneficiary of 75 million pounds. And then to make an onward gift to the foundation. Why do you think he wants to do that?
Maybe you work for the foundation.
Oh, my thing isn't up loud. Say it again.
Maybe he works for the foundation?
No.
To relieve taxes.
Taxes.
If it's charitable and the taxes there would be no taxes, so it'll be very little.
Right. So in a lot of jurisdictions, you'll see if you keep abreast of most of the jurisdictions that have trust as one of their products, you will notice that their legislation is not constantly amended. And this is what this case is going to show you now, that just because there is a request, there has to be a way to deal with that issue without meddling with the legislation, or I guess coming to a conclusion that doesn't make sense. So the trust was valued at 150 million pounds. And he went to the trustees and said he wants to distribute 75 million pounds to himself, and then he wants to gift it to the foundation. So the trustees could have made this transfer directly to the foundation because the foundation was a beneficiary. And if it had done it that way, it would not have triggered any tax liability. But it was the principal beneficiary that the distribution was to be made directly to him first. He said, the principal beneficiary said, once it went to him, as a UK taxpayer, then he would make the transfer to the foundation in such a way as to deliberately trigger a personal UK tax liability. So the court said that it was unusual for them to be asked to approve an arrangement that facilitated the payment of a legitimately avoidable tax. However, the well-established principle that the court's role is purely to focus on trust law and not any consequent tax liabilities could be turned on its head and applied here. So just as the court has no function of ensuring that proper amounts of taxes are paid, the court also has no function of ensuring that proper amounts of tax are not paid. So the court accepted that benefit is not limited to financial benefit, but it can also encompass social and educational benefits for the beneficiary in question. And it can include the application of the trust fund to discharge what a beneficiary feels is his or her moral obligation. So it was significant in this case that the family had agreed a briefing note. And in that briefing note, they set out their family values and the ethos of philanthropic giving. So making the proposed distribution, incurring the unnecessary tax charge, could be considered to be for the benefit of the principal beneficiary. Note that the family was united in their agreement to the distribution being made in that manner. So while the desire to pay unnecessary tax may not be mainstream, the value of promoting broader social benefits today is clear. The court in this case made it clear that previous case law has been too focused on purely financial factors when determining the meaning of benefit. Instead, fulfillment of a beneficiary's personally felt moral obligation should be treated as being for their benefit. The judgment shows a significant development in trust law, which is reflective of modern attitudes, particularly where managed wealth intersects with philanthropy and tax. Wealth generators and beneficiaries of assets, which are held in wealth structures for asset protection purposes, should be comforted by this evolving area of law, which enables them to meet their philanthropy responsible personal tax objectives. Fiduciaries and custodians of private wealth should take comfort in this evolving law, and when considering ESG investing and the extent to which they should take on broad non-financial considerations when making responsible investments. It may be indicative of the direction of travel in respect of these hot topics as well. So you see, it's not on, is in a lot of different areas. You see where the court is, instead of making amendments to the law, is trying to look at the donor, the settlor, or the principal beneficiary, and their purpose for creating the trust. And in their purpose, they would state their values. So remember now, whenever a trustee is faced with a matter that he thinks that he would need the advice of the court to sanction it, he can go to the court and ask the court for their blessing. Any comments?
So that case was really just a matter of them, the trustees protecting themselves, because ultimately they could have decided to just go ahead and do it, right?
Yes.
Okay.
Mhm. I read between the lines because this case, they say it was private. So you can't get the full case. You only could just get a synopsis. And like I said, the synopsis is online in the matter of the May Trust. But I think the trustees were leaning more towards just giving the funds straight to the foundation. So even though all of the beneficiaries had agreed with the principal beneficiary that yes, it goes to him, and then he pays the taxes and send it to the foundation, the trustees was of the view, reading between the lines, that they just wanted to send it straight to the foundation.
I suppose maybe if the foundation was always a beneficiary and was always receiving funds before this happened, maybe they never had a middleman. And so they were kind of trying to figure out, okay, what's the difference now?
Yes, the difference was he was using his morals. As far as he was concerned, he had a moral obligation to pay taxes. He wanted to do it. But then, like we said, the foundation was already a beneficiary. He didn't have to do it that way. But he did. It wasn't necessary at all. All right, so let me just give you all a kind of like a. All right, so this is my jots, and then we could go through the chapters later next week. So how I have thought about it is you have 5 questions and you answer. I mean, you have 5 questions to answer, and I'll give you more than 5. Each one is worth 20 points. So I have a question on the protector. I wrote that down. Remember, we read that article about the protector. I'm gonna do a question on that. Remember the little snippets we did from the new FATF release document on artifacts and blah blah blah. I'm gonna put a question on that. Will we just finish reading on beneficiaries' right to information? There's one on that. I wrote that down. There's a question on investment advisors. There's a question on trust committees. There's a question on artworks.
Say that again, artworks?
Artworks, yeah. I think you did that with Wilkie. When you have these special assets.
Yeah,
I'll say
okay.
special assets. Remember when we did the AML, we looked for red flags? I gave you all a red flag question. Purpose trust and charitable trust. It's a question on commercial assets. I'm gonna do a question on a general question on corporate arrangements and the vulnerability to money laundering. Let me see. How many that is? Okay,
10.
let's see. 10?
Mm-hmm. You said corporate arrangements and its vulnerability to,
Yeah, money laundering. And then I'm gonna put a question that has about maybe 5 or 6 parts, short answers, short answers. Something like explain the following. So it's a mix. And the one on beneficiaries write the information. I want you to discuss 2 cases. So I've given you 3 cases besides Schmidt's.
Ms. Archer,
Mhm.
you say next week you're giving us the questions, right? That's what you
We'll go more into what the questions are specifically.
said? Okay.
Yeah. God just wanted Deandra wanted an idea so she could get started, but I have to write these out. So next week, Thursday, we're just going to be looking at the questions themselves and those areas. Like how you didn't get to read this chapter for the day, you can read it. You see there's a question on it. You can look up your 2 cases and you can come pose with questions if you need it when I tell you how the question is going to be written. So over this Easter holiday, you could look at the FATF artifacts. You could look at I think in your notes, it speaks about the vulnerability of trust and money laundering. I gave you all the reference for that. So you could start to read that. You could read again the chapter on the protector, and there's some cases in there. You can look at the what you did with Wilkie, with special assets and with commercial assets. And so when I tell you what the question is, then you'll have a better idea of how to approach it. So we good? I'm not disturbing your holiday. Who's saying, who grown Jeff now? I could have waited until next week, you know.
Don't mind us being quiet, rewriting.
No, we appreciate you doing this now. That means that we can't get carried away with our weekend.
No, focus.
Yeah.
Focus. Take some time to go over what you need to know so that when we look at the questions themselves, if you have questions, you can put it down. If you don't have questions, you will say in your mind, okay, I read that. I know what that is. I can answer that question. Remember, you're choosing 5. Please,
uh,
please. 5 out of how many? How many that was? 11?
right.
Do not do what I see students always do. If we're going over the questions next week, Thursday, as they choose 5 or 7, just in case when you get there, you change your mind. But I see what a lot of students do is when they get there, they answer 3 questions very well, and then the other rest, no. They end up getting 2 points or getting 0 or getting 1, because you could tell they weren't prepared for it. You have sufficient time now to prepare. It has to be an area that you like. Once you like that area and you study that area, you can answer that question no matter how I change the words, because it's on that topic. That doesn't change the topic. It's just the way in which you answer the question. So you can start now by going over your notes. By next Thursday, when we go over it, you should know which 5 or 7 you're focusing on. And so when the day of the exam comes, there's no need to panic. You should walk in there quite confident and answer the questions to the best of your ability. All right?
Yes, ma'am.
All right, so y'all could go in and see Thursday. You have enough time to run the church. In church.
I just want to confirm the test is on the 22nd of April, right?
Yes, it is.
Okay, good.
Open book too.
No, it is not.
Semi-open book?
That's a good one.
How about open paper?
No,
Like
no.
one paper?
No, you had that after the first one, not this one. This one, you got this.
No, Miss Archer, there's too much 20 points for, I'm glad that you have faith in us, right? But there's a lot for 20 points each, you know. Maybe one sheet of paper could do. Consider it. Thanks.
Or I could play around, instead of making them 20 points, I could make them 10-point questions and give you 2 mandatory ones worth 20 points.
Sound like a better deal.
I think
been-
so.
You want that? 2 mandatory at 20 each, right? That's 40.
And that's 8 things we gotta know.
Then that's
No,
one
yeah,
question. Get the
Yeah,
But we
answer.
wouldn't have so much to answer. You know what it is
Yeah.
to write for 20
And I-
points?
and I give you 6 short answers, so it won't be that long.
You mean 10 short answers so we could choose?
You could choose, yeah, but I'm saying, but
Okay.
giving
Okay.
me, I give you 2 mandatory questions worth 20 points each and 6 short answers. I could do that.
And so
think that's
you'll
a better one.
let us know what's going to be the mandatory area then.
Yes, I will tell you what is mandatory.
Okay.
That's better?
It's, I think so.
Okay.
Yeah, I think so as well.
We'll make
right.
it work.
Okay. Sounds good. All right, so I'll write it out. And
Miss Archer,
yes, my dear.
so after you come from church tomorrow, God's willing, you don't think that you should send us the questions so that we can go over that during the Easter holiday? I'm just thinking.
I have to write it. I have 3 exams to write.
Okay, do ours first. Please. That would
Tomorrow
make
is,
sense.
tomorrow
Okay,
is
but
good.
Saturday evening, and then we have Sunday and Monday. We have our questions, so that when we come to class on Thursday, when you ask the questions, you could just tell us, well, no, you need to add to this. This is 20 points. You need more information, that kind of thing.
We could do that on Thursday. Thursday, when I tell you what the question is, people who had me before will tell you, I'm going to tell you, no, that
Yeah.
is not.
Yeah.
I'm going to tell you that. I'm going to tell you, just be prepared. I have to see how I'm feeling to see what I'm going to make mandatory.
Have a nice, restful
Mm-hmm.
time before you write them then.
Mm-hmm.
All
Hey,
right.
Janice, think about Jesus dying on the cross.
Right.
Yes. And have some good wine, not the cheap wine that time, the good stuff.
Exactly.
You all are just too much. You all are
Okay.
too much.
We got this.
So enjoy your holiday.
You too.
Everybody, have a good Easter.
To Miss Acho.
Okay.
Good night,
Mhm.
everybody, and y'all be
Good
safe.
night.
Yes,
Good
Laverne.
night.
Go to
Happy
church.
Easter. Bye.
Bye.